Please ignore my crazy hair. Okay, so there's this video that's been circulating around. I will link the original to the doobly-doo. But it is a video about a girl who was arrested for essentially doing nothing in Alaska. And this really aggravates me because I am a criminology and criminal justice major. Ha! I'm gonna get that out there. I'm going to school to be the type of person you hate. Ha! Fun stuff. Okay, so anyway, in the video, somebody faked a 911 call to their house, already illegal, saying that they were going to commit suicide. Alright, totally legit to investigate the call. But there are a couple things that were done wrong on both parts, but this just gets absolutely outrageous. They intimidated the mother, or the female owner of the house, to let them in because they said they had a right to be let in and they didn't. They are legally obligated to stand at the door, knock at the door, you answer the door, you say, "Oh, hello officer, how are you? Why are you here?" And they tell you, and they get to ask you a couple questions, and they ask if they can be let in. You have the option to say yes or no. If you say yes, they are only allowed to look and see. They are not allowed to search for anything. And if it is something, like if they find something for some reason that it isn't why they were called there, then they're not allowed to make an arrest about that. They were called for an attempted suicide. The attempted suicide was not happening. And so they were supposed to, say thank you for your time, sorry to disturb you, and move on. Now, what eventually ended up happening was this girl came up and she said, "I want you gone. There's no reason for you to be here." And she called them on their bullshit. Now, the reason that this really aggravates me is because this guy is so suffering from a power trip. It's not even funny. Now, I can understand that his gun is holstered on the left side, and by the time he turned and she reached for the door, it was on his left side. But the problem here is that when she reached for the door and he apparently thought that she was reaching for his gun, he shoved her back, which nullified any threat that he felt at that moment, and then proceeded to knock her to the ground. No, bad. You should be ashamed. Anyway, and then he proceeded to handcuff her, then carry her out to the car, and put her in the car. The entire time she is screaming, "What am I being arrested for? You cannot put me in the car without telling me what I am being arrested for. You are required by law to tell me what I am being arrested for," and this is the truth. He is required by law to tell her what he's being arrested for by the time he puts the cuffs on. And she says in the video, apparently he sees I'm going to be polite here, and say water pipe, but we all know that I actually mean the other word for that, and asks her if there is any marijuana in the house, and she says, "I've smoked marijuana in the past, that does not mean that I do it now," and he then accuses her of being a drug abuser. Now, I'm one of those people that really want marijuana legalized, not because I use it, not because of any other reason other than I'm really tired of people arguing about it. For the most part, it doesn't really do much harm. Yeah, it makes people slightly unproductive and slightly lazy, but hey, in my opinion, that just rules out who is going to be a good candidate for a job. Okay, now, I have my Introduction to Policing textbook right here that I got fall semester. I have a whole stack of law textbooks. I took 4 criminology classes in the fall semester, and I'm looking up the definition for the Miranda rule, the Miranda warning right now. And it says, rule established by the U.S. Supreme Court in the landmark case Miranda v. United States in 1966 that requires the police to advise suspects confronting custodial interrogation of their constitutional rights. Okay, what that basically means is that you basically say you are under arrest for blah blah blah, you have the right to an attorney, you have the right to remain silent, basic jazz that you see in the films, and if any of my audience has been arrested before, then you've had your Miranda rights read to you. Okay, now, so that's Homeland Security. There is an index in here. And I will look up, see this bibliography, and I will look up the passage and read it for the Miranda rights, because they did not read her Miranda rights. They refused to tell anybody why she was being arrested, and this just bothers me, like, a lot, because this is something that I'm going to school for, and I want people to do their freaking job. .411 and .412. And I went over this in all 4 of my classes. I don't know why this guy was doing this. Okay. And 3rd degree. Okay, the path to Miranda. The police have many crimes to investigate and often not enough resources to accomplish their mission. This is a fact. In many cases, there is not enough physical evidence or there are no eyewitnesses to assist the police in their investigation. Thus, police must seek to gain a confession from a defendant, particularly in murder cases, in order to gain a conviction. The history of methods used by the police to obtain confessions from suspects has been sorted, including beatings and torture that came to be known as the 3rd degree from 1936 until 1966. The Supreme Court issued a number of rulings to preclude this misconduct and ensure compliance with due process as guaranteed by the Bill of Rights. Okay, this right here already says what they did to her violates the Bill of Rights in the Constitution. The following landmark cases show the development of rules regarding the custodial interrogation during those 3 decades. See Table 1311 for a list of landmark cases and rules leading to the Miranda decision. Okay, so we have Brown versus Mississippi, which happened on March 30th of 1934, and the case took place in 1936, so 2 years later, and it says Raymond Stewart was murdered. Okay, so we got a murder case right here. On that night, Deputy Sheriff Dial went to the home of Ellington, one of the defendants, and requested him to accompany him to the house of the deceased, and there a number of white men were gathered, who began to accuse the defendant of the crime. Upon his denial, they seized him and hanged him by a rope to the limb of a tree twice. Not once, twice. That tells me that they didn't tie the noose properly to break his neck, or they just lifted him up high enough off the ground to suffocate him, then revive him immediately afterward, beat the living crap out of him, and then do it again. I understand that this is 1936, but people, the past does not give you an excuse to not be a decent human being. When they took him down the second time, they tied him to a tree and whipped him. I can already tell right now that this man's black. The trial records show that the signs of the rope on his neck were plainly visible during the trial. He was again picked up a day or 2 later and again severely beaten until he confessed. Okay, so he was already tried for this, picked up after the trial, and then beaten until he confessed. The other 2 defendants, Ed Brown and Henry Shields, were also arrested and taken to jail. In order to obtain the confession, the defendants were made to strip, and they were laid over chairs, and their backs were cut to pieces with a leather strap with buckles on it, and they were likewise made by the same deputy, definitely to understand that the whipping would be continued unless and until they had confessed, and not only confessed, but confessed to every matter of detail as demanded by those present. There was a part of me as a little kid that honestly thought that kind of stuff only happened in movies, in bad movies at that. Actually, wait, no, some of them were actually pretty good, but most of the time I thought that this happened in movies, and then I get older and I go to college, and no, this happened. This happened in real life. The defendants made their confession on April 1st of 1934, were indicted on April 4th, went to trial on April 5th, and were convicted and sentenced to death on April 6th. The deputy sheriff who administered over the beatings, Deputy Sheriff Dial, testifying in court, responded to an inquiry as to how severely a defendant was whipped by stating, "Not too much for a Negro, not as much as I would have done it if it were left to me." On appeal, the Supreme Court ruled that the actions against the 3 men were violations of their due process rights. That was just one case. I'm not even going to go to the other two cases that go to the end of the third degree. I'm going to skip right over to the Miranda rights. Okay. So, Miranda rights is Miranda versus Arizona was the culmination of many Supreme Court decisions focusing on the rights of individuals during police interrogations. Okay, this was all during police interrogation. The Miranda decision was actually a combination of case involving 4 persons. Ernesto Miranda, arrested in Phoenix for kidnapping and rape, Michael Vignera, arrested in New York City for robbery, Carl Westover, arrested in Kansas City for robbery, and Roy Stewart, arrested in LA for robbery. Okay, so obviously this is named after the guy who was arrested for kidnap and rape. But the thing is that, as I've said before a couple times, this all right here, what I'm reading out of this book right here, this section says the Miranda ruling. This all has to do with police interrogation, which unofficially was going on at this young woman's house. In Miranda, the Supreme Court ruled that confessions are by their very nature, inherently coercive. Like they were trying to do to that girl. They said, your mother's freedom is at stake if you don't answer my question. She answered their question. And that custodial interrogation makes any statements obtained from defendants compelled and thus not voluntary. She was obviously aggravated that they were there. The court felt that interrogations violate the Fifth Amendment, the right to remain silent. I know that's due process, which guarantee that no one shall be compelled by a witness to be a witness against himself or herself in a criminal case, and that is this guarantee is violated any time a person is taken into custody and interrogated. The court then established the well-known Miranda rule or Miranda warnings, which state that prior to any interrogation of a person in custody, the police must do the following: advise the suspect that he or she has the right to remain silent. Advise the suspect that anything he or she says can and will be used against them in a court of law. Advise the suspect that he or she has the right to consult a lawyer and to have the lawyer present during questioning. Advise the suspect that if he or she cannot afford an attorney will be provided free of charge. The court further ruled that if before or during the interrogation the suspect in any way indicates a wish to remain silent or to have an attorney, the interrogation may no longer proceed. The Miranda rule applies to all custodial interrogations. However, this does not mean every police interview requires the warnings. Court has made it clear that Miranda rights apply only when the suspect is both in custody. This girl was in custody and subject to interrogation. She was both. She was in custody and she was subject to interrogation by the police officers. And they didn't read her Miranda rights when they handcuffed her. They didn't even tell her what she was being arrested for, and she was arrested for reaching for a door. That's what she was arrested for, and I am highly disgusted by these people, because this is what I'm going to school for, and this is the type of behavior that gives people like me who are going to school who, I don't even actually want to be a cop. I want to be a forensic scientist. I want to sit behind a desk and look at test tubes for the majority of the day. And the kind of stuff that was pulled by these Alaska State Troopers is the type of stuff that makes it really hard for me to talk about what I'm going to school for. Because the moment that people hear, oh, my major's in criminology and criminal justice, they don't even wait for me to mention that I have a minor in chemistry, that I'm going for a minor in chemistry, and my focus is in forensic investigation. As soon as they hear criminology and criminal justice, they start ramming into me about gun control, about marijuana legal stuff, and the police brutality problems that have been going on as of late and in the past, and all this other stuff. And I'm just like, I honestly have to stop people and say, I don't want to go to school for that. I want to go to school to collect the evidence and verify that the crime actually happened the way that the detectives are saying that it happened. And I don't see anything wrong with this. If anything, I'm looking out for your rights more than most people, because when people ask me, why are you going to school to be in criminology and criminal justice, I tell them the same thing. I'm going to school for criminology and criminal justice because I do not remember a time in my life when I did not want to be Batgirl. And I don't. I don't remember a time in my life when I didn't want to be Batgirl. I always wanted to be Batgirl. Hell, I still want to be Batgirl. I wish I could be Batgirl. Hell, if this doesn't work out for me, I may go to school to learn library science stuff and be a research librarian and work in museums, handling old documents, wearing gloves. But yeah, that's my rant. Alaska screwed up. Well, Alaska State Troopers. Oh, and their fan Facebook page is blocking anybody who brings this up. So, if you want to make some noise, go ahead and blow this up, because I will link the original video. These guys did not do their job. And I'm getting a little bit heated here. But here, let's read the actual case. On March 2nd, 1963, in Phoenix, Arizona, an 18-year-old woman walking to a bus stop after work was accosted by a man who shoved her into his car and tied her hands and ankles. He then took her to the edge of the city where he raped her. Okay. So far, this guy's guilty. The rapist drove the victim to a street near her home and let her out of the car. On March 13th, the Phoenix police arrested a 23-year-old 8th grade dropout named Ernesto Miranda and charged him with the crime. Miranda had a police record dating back to when he was 14 years old. He'd been given an undesirable discharge by the Army for being a peeping Tom. This guy already has a history of escalating to rape. That's the other thing. I want to be a forensic scientist. For a really long time I wanted to be a forensic psychologist, and I did a lot of profile reading, and this guy having a prior at the age of 14 for being a peeping Tom, this already tells me that he's going to escalate to some sort of sexual crime. More than likely. Unless he gets off on being a voyeur. But considering that he raped a woman, I'm pretty sure we're going to just go with my first statement. And had served time in federal prison for driving a stolen car across a state line. Miranda was placed in a lineup at the station house and positively identified by the victim. He was then taken to an interrogation room where he was questioned by the police without being informed that he had a right to have an attorney present. 2 hours later, police emerged from the interrogation room with a written confession signed by Miranda. At the top of the statement was a typed paragraph stating that the confession was made voluntarily without threats or promises of immunity and with full knowledge of my legal rights, understanding any statement I make may be used against me. Until Miranda was passed, crap like that could happen all the time. All the time, in every single case. They had templates in police databases that had that paragraph saved at the top of a whole bunch of letterheads, and it said word for word, I am aware of my rights, and this confession has been made voluntarily with no threats, no promises of immunity, and I am fully aware of my legal rights. And most people weren't. Most people were not. People would ask for their one phone call and would be denied their one phone call. Ask for a drink of water, they would be denied their drink of water. It was basically civil torture. I'm gonna see it. And this girl was basically assaulted by the police officer. By shoving her back, he immediately nulled any threat that he felt was happening to him at that moment. And in police academy, they teach you to meet force with an equal amount of force. Cops need to know, and I'm going into this knowing that I'm going to get a certain amount of verbal abuse every day. And I am more than okay with dealing with that. More than likely because I'm going to be sitting behind a desk all day. Looking at test tubes and particulates and probably gun casings and that kind of stuff. But my heart's actually pumping, like, really hard because I'm really mad right now. But when she answered their question and they went to leave, he got rid of any threat that he felt when she reached for the door. He didn't have to knock her to the ground. He didn't have to put her in handcuffs. He didn't have to carry her out to the car. I am more than okay with this girl resisting arrest until she was told what she was being arrested for. I am okay with her trying her best to not get into the car because she legally did not have to get in the car until they told her what she was being arrested for and was read her Miranda rights. And she, in my opinion, she had a right to make a fuss about it. Because she was being taken against her will without being informed what she was being arrested for. And that's not legally correct. These men whom are associated with the career that I want to be a part of did not do their jobs legally. And I don't know if this man was suffering from a power trip that day, if he was just having a bad day, but he needs to have his records, he needs to have his files reviewed. Because I don't even want to think about how many other times he's pulled stuff like this. And if he's pulled like stuff like this before, if it's a common thing for him, he really needs to go on suspension. That's all I got.